Members, welcome to the 21st meeting. Let me welcome the administration to our meeting. So just to briefly report to members, as at the specified deadline yesterday, the Secretariat had not received any proposed amendment from any member, and the Secretariat already circulated the proposed amendments from the administration to members. That's CB bracket 2 304/2024 bracket 01. Hard copies of the paper have already been tabled for members' reference. Now, without further ado, I will invite the administration to walk us through the amendments, and then I will also invite the legal advisor to confirm that the committee stage amendments are free of error in terms of the point of law and drafting issues. And members, if you want to speak, please press a button. We will go through the paper now. Members, please turn to the annex to the paper. We've adopted a revision mode so as to compare the versions before and after the amendments, and we also provide footnotes to explain the rationale behind the proposed amendments. So pages 1 and 2 of the annex relating to the preamble, there is an amendment in relation to an international organization. Some members were of the view that these phrases need to be changed. The original reads countries, regions, or places, and there is an ambiguity that this international organization may have one or more than one persons. Now, to dispel this possible misunderstanding, we are providing an amendment which reads an organization, the members of which include two or more countries, regions, places, or entities entrusted with functions by any country, region, or place. Thank you. Any questions? Dr. Loy Kwok. I find this amendment suitable. The term international organization will appear again in subsequent paragraphs, such as external force. An external organization includes one member from one country. And as such, we don't need to further broaden the scope of international organization to include organizations, the members of which include just one country. So as there is no need to further broaden the scope of international organization, and by introducing this amendment, I want to know that this will no longer entail the implications I just referred to. Yes, Chairman, this definition will be adopted throughout the bill. This is a suitable definition. What I'm trying to say is you want to use this term international organization, and there is no chance that you'd want to further broaden the scope to cover more organizations, right? This definition will apply throughout the bill. And the problem I earlier cited would not emerge. Is that right? Can you confirm that? Yes. Please continue. Still on page 2, section 6, the definition of external force. Now, if we turn to page 3, you will find the amendment. The original reads the authority of a place, the authority of a region or a place of. Some members commented that by external force, it already means that it belongs to a region or place. So we've taken this suggestion on board. We are going to delete the phrase a region or a place of, an external place. No questions? Please go on. Page 4 of the annex at the bottom. Clause 12, requirement on disclosure of commission by others of offense of treason. The amendment can be found in subclause 4 on page 9 of the English version. The original reads the offense of misprision of treason under common law is abolished. And to provide greater clarity, it now reads this section provides for the offense of misprision of treason under common law as a statutory provision with appropriate improvement. Thank you. Any questions? Right, please continue. Clause 19, inciting disaffection of public officers. This can be read together with clauses 19A and 29A. Clause 19 refers to the definition of public officer. Now, on page 11 of the English version, we've added point G is a class of persons specified under section 19A. During scrutiny of the bill, some members put forward some strong views. Certain public organizations have an important bearing on the interests of the HKSAR, and it may pose national security risk if disaffection is incited among their staff members. Some public organizations may have a greater chance to have access to state secrets. The bill, as it stands, do not cover staff members of these organizations as public officers, and members have suggested empowering the Chief Executive in Council to expand the scope of public officers in respect of the offense of incitement to disaffection. We consider this approach forward-looking, which can allow more effective implementation of the ordinance. Questions? Mr. Chan Sil Hong. Thank you, Chairman. 19, 19A and 28 amendments are made to these clauses in response to members' suggestions. These are not officers of emolument within the government, but they may involve vital interests of the HKSAR, so I support adding point G under the definition of public officer. I just want to know whether this is how it is usually drafted, a class specified so and so. Well, a person includes office or staff members. Here, it refers to a class specified so and so. Now, if the CN Council then broadens the scope of public officers, is it that it refers to not an individual per se, but the position that this person holds? Or would you just rather delete the words a class and then just put down a person specified under section 19A? And then you can then refer to section 19A for the specification. Who would like to explain the rationale, please? Ms. Siu. Now, we use the term class because we don't want to pinpoint any individual. As you can see in the previous paragraphs, the word class can be found. For example, a person appointed under the Exchange Fund Ordinance and other office-bearing positions such as a staff member of the ICAC and a staff member of the Ombudsman. These are classes of persons to be specified. We want to provide a broad scope so that the C in Council can specify the class of persons to be included. Ms. Carmen Can. I thank the administration for taking on board my suggestion so that we can take a more forward-looking approach in handling the definition of public officer in this very important piece of legislation and how it applies in the future. I have a question about this. Publish a notice in the Gazette. Does it mean that this is a piece of subsidiary legislation and that negative vetting procedure will be adopted? Who will take this question, please? Ms. Siu? Thank you. I confirm that. It carries a binding effect, so the order will be published in the Gazette. Mr. Holden Chow. Yes, also a point of procedure. If this is to be implemented, the order should first be published in the Gazette, and then subsidiary legislation will be enacted, followed by negative vetting in this Council. Is that right? Ms. Yu? Yes, agreed. This will be done by way of subsidiary legislation as well as negative vetting in accordance with CAP 1, that is IGCO, for approval by the Council. Mrs. Regina Ip. Another member asked my question, so I don't want to repeat. It's also about negative vetting and subsidiary legislation. Mr. Jeffrey Lam. Yes, I agree with this proposed amendment. In our deliberations, we discussed persons holding an office of emolument under the government, and now it will include other staff members of public organizations. The public organizations may have different functions and duties, so I agree with the additional point G. Right? No other questions? Please continue. In fact, next, when we turn to 19A, specification of public offices, some members already referred to this part. For the purposes of Section 19, the Chief Executive in Council may, by order published in the Gazette, specify a class of persons as public officers if the Chief Executive in Council reasonably considers that it is necessary for safeguarding national security to specify the class of persons as public officers. No questions? Okay, that's similar to the previous provision. Please continue. The interpretation clause, clause 28. 19 and 19A refers to incitement to disaffection. 28 refers to offenses relating to state secrets. Again, under the definition of public officer in clause 28, we add point G, a person of a class specified under 29A. Right, I think this is the same as the previous provision. No question. Next. Page 15 in the English version. 29 capital A, specification of public offices. For the purposes of this division, the C in Council may, by order published in the Gazette, specify a class of persons as public officers if the Chief Executive in Council reasonably considers that it is necessary for safeguarding national security to specify the class of persons as public officers. Ms. Carmen Can. I see the Chinese version for the purposes of this division. In 19A, however, for for the purposes of Section 19, can you explain the difference? Who will take this question, please? DS. For 19A, it applies only to the previous section, that's Section 19. Whereas for 29A, the same term can be found throughout the division. That is why in 29A we use this division instead. So apart from this reference to Section 19 in 19A and this division in 29A, there is no reference to the term public officer in the bill, right? Yes. No other questions? Please continue. Thank you. Chairman. Next, Clause 32, unlawful possession of state secrets when leaving HKSAR. Members will find the amendment in departure conveyance or cross-boundary conveyance. For the offense of unlawful possession of state secrets when leaving HKSAR, for a person leaving the HKSAR on a cross-boundary conveyance, we propose to change it to departure conveyance so that it suits what is described here when this person leaves the HKSAR. In English, this amendment also applies. That is a change from cross-boundary conveyance to departure conveyance. Mr. Holden Chow. I think that we now are given greater clarity. It means leaving Hong Kong and instead of using a cross-boundary conveyance. Now, after changing the term from cross-boundary to departure, what if somebody in possession of state secrets leaves Hong Kong and then for some reason it may be possible that this person now returns to Hong Kong? Say at the time when I leave the territory, I'm in possession of the state secret, and when I come back, I'm still in possession of the secret. And then what happens if I'm caught? If the offense is only discovered at the time of my return, then this is not evidence relating to my leaving the HKSAR. I am only caught at the time when I return. So in terms of how evidence is to be handled, there will not be any implications, right? Because this categorically refers to departure. But what happens if the scenario I described happens? In terms of gathering evidence, by using the term departure conveyance, it will not cause any problems, right? Ms. Siu. Now we want to provide clarity by improving this term because the original reads cross-boundary conveyance. It may not be clear that somebody is actually leaving the HKSAR. Cross-boundary usually refers to one traveling to and from Hong Kong and mainland, and this does not affect the evidential issue. Right, as long as we explain this clearly in this proceeding, it will not affect the gathering of evidence in the future, as long as we understand that it refers to both cross-boundary and departure conveyance. Mr. Lai Tong Kwok, my comment is this. This is a definition. So we look at what it actually means. It means a means of transport engaged on a journey leaving the HKSAR. That means the policy intent is to cover only the departure journey. The first point is that be it the original or the amendment, they don't cover the returning journey. Is that right? Second, the intention is to cover the unlawful possession of state secret and leaving HKSAR. Even if this person subsequently returns to Hong Kong with the state secret, we can still charge him with unlawful possession when leaving HKSAR.
No further supplement. Thank you. Mr. Jeffrey Lam. Chairman, there are many ways people can bring state secrets outside of Hong Kong. I have a simple question. Of course, we can look at whether a person has the lawful authority to bring state secrets outside of Hong Kong. This has to do with smuggling. Well, we won't specify here whether the state secrets will be brought outside of Hong Kong through smuggling. That means it covers circumstances when a person brings state secrets outside of Hong Kong. Is that right? The key is that the person does not have the lawful authority to bring the relevant information outside of Hong Kong. Please carry on. Now we come to Clause 38, extraterritorial effect of this division. 38 bracket 1b. There is a part that says 33 bracket 6 or bracket 7. It is a typo, so we have changed it to 33 bracket 6 or bracket 8 instead. Any questions? If not, please carry on. Thank you, Chairman. Now we come to Clause 40, declaration of prohibited places and authorization of guards. This amendment is proposed in response to views expressed by members during the examination of the bill that the government should state clearly in what way would the chief executive make an order to declare a place as a prohibited place. Therefore, we add the phrase here, by order published in the Gazette, to enhance the clarity. Thank you. There being no further questions, administration, please carry on. Now we come to Clause 41, espionage. The amendment is set out on page 23 of the English version. Subclause 4C is originally about a statement of fact, and we define how a statement of fact is misleading. There were views expressed by members that the definition of misleading is too narrow. So after consideration, we think there is no need to define the term, so we have deleted the definition here. Any questions? Please carry on. Thank you, Chairman. Now we come to Clause 47, sabotage endangering national security. The amendment is on page 28 of the English version about the scope of public infrastructure. The amendment is at Clause 4, Subclause 4b. The original provision is public means of transport or transport facility that is situated in the SAR. There are strong views expressed by members that the term public infrastructure should cover public transport infrastructure and logistics infrastructure, such as cargo terminal, as well as infrastructure for financial services, such as the Hong Kong Stock Exchange and the transaction system. We agree with the views, so we have added non-exhaustive examples of public services to illustrate the wide scope of public services. So we have added the phrase public transport infrastructure or public transport facility in subclause 4b. Also, for subclause 4c, in terms of items listed out, we've added item providing or maintaining public services such as finance, logistics, water, and so on. And below that, we've added A, infrastructure, or B, facility. Thank you. Mr. Tony Che. I think this amendment make the provision more detailed. As mentioned, logistics infrastructure and infrastructure for financial services are all key infrastructure. So I support this amendment. I have a question about the English translation or the Chinese translation. In English, when we say transport, the Chinese version is 交通. But as far as I understand, transport can also be translated as 運輸 in Chinese. Say for cargo terminals, if we want to transport cargo, we say 運輸 in Chinese. So these should be considered as logistics infrastructure. We seldom call cargo terminals transport infrastructure. I'd like the administration to explain the Chinese translation here. Thank you. Drafting Division, or Deputy Secretary first. Thank you, Chairman. On logistics infrastructure, we added an example of logistics in subclause 4c. So I would regard cargo terminal as a logistics infrastructure, so it is covered in this clause. I understand that for subclause C1, there are A and B. It is infrastructure or facility, so it covers not only transport infrastructure but also logistics infrastructure. Mr. Tommy John. Chairman, I support this amendment to cover, for instance, cargo terminals and infrastructure for financial services. Say, for instance, someone stages a financial war to affect our SWIFT system or linked exchange rate system. Would this clause cover this circumstance? Well, we are focusing on acts of sabotage endangering national security in this clause. For other types of acts that may endanger national security, we'll have to consider the actual circumstances. So would, say, financial war be covered under this clause? Our purpose is not to broaden the interpretation or definition. We just want to cover more public infrastructure here. Mr. Jeffrey Lam. In the previous meetings, I suggested that apart from the infrastructure originally listed out here, we should also include infrastructure for financial services. We have to protect our financial system. Even with inclement weather, we had to resort to the manual system. But this is because with just a click of the button, the system could be damaged. Financial services can easily be affected by external interference. Therefore, I suggested adding infrastructure for financial services here. So we have to tread carefully here and study how we can implement preventive measures. Therefore, I agree that there should be this amendment in place and that the SAR government should pay more attention to what kind of preventive measures it can adopt. Mr. Chen Xiu-hong. Thank you, Chairman. We want to have a list of public infrastructure that is as detailed as possible, including infrastructure owned by the government. I see that the way it is drafted here now covers most of the public infrastructure. The administration added clause 4C1, under which there are A and B, that is infrastructure and facility. If a public infrastructure is paralyzed, then it would no longer be in operation. So I think it's important to add infrastructure and facility here. In the other clause, there is only mention about equipment owned by the SAR government. But here, it's more exhaustive because it covers infrastructure and facility. I think this makes it more comprehensive. And I wonder this is the intention of the drafting division. Deputy Secretary, when we drafted C1 here, we tried to cover all scenarios. We make it more exhaustive because we added the term providing or maintaining public services. So we have broadened the scope here. And to avoid any confusion, we added capital letters A and B below to state clearly that the public infrastructure that we refer to include infrastructure or facility. And we think that the scope is wide enough. Even without the word equipment, providing or maintaining public services include any equipment that may be affected. So I think it covers scenarios in which there are people that try to paralyze any equipment or facility. I think facility covers equipment. I agree, Chairman. It's just that for subclause 4A, Roman numeral 2, there is facility or equipment. But here in the amendment, it only covers facility in the added part. But because the drafting division added the word maintaining public services, so I believe it covers all infrastructure owned or occupied by the central authorities and the government. So I have no problems here. Ms. Carmen Khan, I see that the amendment here is in response to views expressed by us, so I would like to thank the administration for taking on board our views. For subclause 4A, it refers to public infrastructure that belongs to the central authorities or the government, or is occupied by or on behalf of the central authorities or the SAR government. But for C1, it refers specifically to public infrastructure situated in the SAR. I think it's crucial that we add the word maintaining here for public services. And here for the scope of public services, it includes finance, logistics. But how about computer and electronic system? Is it restricted to the interpretation in the sense that it is situated in the SAR government as well? And should we further broaden the scope of public services in order to move with the times, because this clause has to do with sabotage endangering national security? Or is it the administration's view that it is broad enough in terms of the scope, and that the chief executive does not have to be given the power to publish a notice by Gazette to widen the list of public infrastructure to be included? Deputy Secretary. The central authorities or the SAR government may own facilities or infrastructure outside of Hong Kong. That's why we mention specifically that we are referring to facilities situated in the SAR. For C1, we are not only referring to facilities owned by SAR or the central authorities. That's why we do not specify those outside of Hong Kong. As to whether we should empower the Chief Executive in Council to amend the list of public infrastructure here by way of subsidiary legislation, well, unlike the case of public officer, which is an exhaustive list, here we have a non-exhaustive one. We are just listing out what kind of public infrastructure that may be covered under our definition, and we think the scope that we are covering now is quite broad, and we don't think it is necessary to empower the Chief Executive in Council to further amend the list in the future. All right, Dr. Lo Wai Kwok. I support the amendment proposed here. It shows that views expressed by members have been considered. The general public should agree that public infrastructure is important. Back in 2019, MTR stations as well as railway services were constantly damaged. I believe we all have fresh memory of that, and so I believe the amendment here will be supported by the general public. I will not touch on the point about public infrastructure here, as it has been covered by other members. Clause 48 covers a wide scope as well, because it has to do with computer or electronic system. Many public infrastructure, including public transport infrastructure or public transport facility, and even infrastructure for financial services, adopt electronic systems. I believe all these systems are covered by the clause here, so I'm not too worried.
Official, please. Thank you, Chairman. Next up, we come to Part 6 about external interference endangering national security and organizations engaging in activities endangering national security. The proposed amendments are about Part 6, Division 1, and Clause 50. We propose adding endangering national security. If someone colludes with the external force through inappropriate means, well, that is a person who would intend to bring about an interference effect, collaborates with an external force to do an act, and uses improper means when so doing the act commits an offense, including commercial, academic interactions. These are materially different. In order to accentuate the nature of the offense of external interference, we propose adding the phrase endangering national security after external interference. The elements of the offense remain unchanged. That is just a change to the name of the offense. Dr. Lo Wai-kwok. Thank you, Chairman. Regarding the amendment to the title of Part 6, that is quite important. When scrutinizing Division 1 of Part 6 about external interference, I also pointed out that when one collaborates with an external force, under Clause 52, there is also reference. Well, I mean, external interference is neutral. It is the reason that is key. When the purpose is to endanger national security with the use of improper means, we already touched upon it and explained very clearly during the scrutiny of the bill. In the public consultation period of the Article 23 of the Basic Law, we also heard worries, misunderstandings, or deliberate distortion of the term external interference. That is, the government is restricting all interactions or collaborations with international organizations. We also need to step up publicity apart from amending the words. We need to rebut when necessary. I can see that the government is working well in this regard. The textual amendment, that is by adding the words endangering national security, is very clear. It does not point to all international organizations. It does not mean that all international organizations are negative. I support it. Next, Mr. Holden Chow. Thank you, Chairman. I support the amendment as well. In the Bills Committee, we did understand the concept of external interference and collusion or collaboration with an external force and the use of improper means. All of us were very clear about that point. When we add the word endangering national security following external interference, that will set the public straight on this point. I support this amendment, and I believe this will also serve the purpose of explaining this division clearly. Next, Mr. Jeffrey Lam. Thank you, Chairman. I'd like the administration to clarify collaboration with academics, with the industrial sector and the commercial sector. I thank the administration for making clarifications not to cover interactions that are reasonable, legitimate, and lawful. This is very important to Hong Kong as an international financial center and the status of Hong Kong. I support this amendment. Thank you. Please proceed. Thank you, Chairman. Next. On Clause 53, page 30 in the English text, meaning of using improper means. Using improper means is one of the charged elements of external interference endangering national security. Under Clause 53, Subclause 1, Roman numerals 5, causing mental injury to or placing under mental pressure on a person, we made reference to National Security Act 2023 of the UK. We made reference to spiritual injury. We have further studied this subclause, and we found that the term spiritual injury used by the UK is intended to cover the potential harmful impacts on an individual's spiritual or religious well-being that could be directly caused by another individual. For example, excluding a person from the membership of an organized belief system or banning them from attending a place of worship. That is different from the legislative intent of the administration. Clause 113(4) uses the term psychological harm on the offense of unlawful harassment of persons handling cases of work concerning national security. So we propose changing Roman numerals 5 to causing psychological harm to or placing undue psychological pressure on a person. That better reflects the legislative intent of the administration. Mr. Tommy Zhang, I thank the government for taking on board my suggestion. The original version, that is, the word mental, has been changed to psychological. Well, I think this is more suitable. Mr. Holden Chow, thank you, Chairman. I also support this amendment. I'd like to add a little bit more. Back then, when the UK used the term spiritual injury, there was a context as well. There were terrorist organizations causing different harm or damage. So probably that was the reason why the UK focused on this context and used this word accordingly. But according to what I know, and I stand corrected if I'm not correct, using the term psychological harm is clearer. It's safer. It has a wider scope. In other provisions, there is also reference to psychological harm. It is also used in other provisions where there is any religious well-being being damaged or spiritual well-being being damaged that can also be covered under the term psychological harm. So I believe the use of the word psychological harm is more suitable. I support this amendment, and I also consider this amendment appropriate. Thank you, Mr. Holden Chow. Please continue, official. Thank you, Chairman. Next up, Clause 56 in page 31 of the English version. That is about interpretation. About political organization of an external place. That concerns contact with these organizations. In definition B, under this definition, there was the reference of a region or place. We propose deleting these words, as we think that the definition of an external place has already included a region or place. If there is no question, please continue. Clause 59. Matters following prohibition of operation of local organizations. We can refer to page 34 of the English text, as well as page 35. These are amendments to subclause 5 and 6. There is reference to in the specified ordinance. But then, upon review, some specified ordinances may not use the expression winding up in the relevant provisions. We propose making this amendment to cover any other provision that has the same effect. If there is no question, please continue. Thank you, Chairman. Next up, we have come to Clause 60 in page 36 of the English version, that is about prohibition of participation in activities of prohibited organizations. Please refer to page 37 of the English text for the amendment. Under subsection 3, we propose adding brackets AA, and we also propose deleting subclause C. Members pointed out during the scrutiny of the bill that while some members of a dissolved prohibited organization may participate in the course of the winding up of the organization for legitimate reasons, they may commit an offense of acting as a member of the prohibited organization as a result. That is why we propose providing for a system by which the Secretary for Security can issue a written permission. We propose deleting subclause C because subclause AA will already cover the original subclause C. That is why we propose deleting subclause C. Ms. Carmen Khan, I was worried about the original version, but then after the amendment, I'm relieved. This sets out what is legal and what is not legal. But should we also change subclause D to subclause C? Because the original subclause C has already been deleted, so subclause D should be changed to subclause C. Thank you, Ms. Carmen Khan. Like all the amendments or provisions, we will not change the subclause number at this stage. After the clause-by-clause scrutiny and the CSA stage, we will once again check all the clauses to make sure that all the order is in place. Thank you, Ms. Carmen Khan. If there is no further question, please continue. Thank you, Chairman. We've come to Clause 63, capital A in page 38 of the English version. Shadow organizations of prohibited organizations. Since members pointed out during the scrutiny of the bill that since an organization is dissolved if the operation of it is prohibited according to Clause 59, brackets 1, there may be queries about whether there will still be office bearers or members of a dissolved organization in respect of offenses in connection with prohibited organizations under clauses 60 to 63. To avoid future disputes, it is proposed to add this amendment to clearly specify that the prohibited organization under clauses 60 to 63, including an organization prohibited under clause 58 in clause 60, should include the shadow organization of the organization, that is, the organization which holds itself out to be the prohibited organization, so that the offenses in connection with prohibited organization under clauses 60 to 63 would also apply to its shadow organization. Mr. Jeffrey Lam. I support this amendment. I propose this word shadow as in shadow organization or shadow director. These examples do happen in everyday life, and the word shadow has a very wide scope. I thank the administration for taking on board my view. Mr. Tony Tse, thank you, Chairman. I'd like to ask a little bit more about this point. First of all, I support this amendment, but in relation to the Chinese version in subclause 3, that is, holds itself out to be another organization. What is the concept behind it? In the English version, it is holds itself out to be another organization. I'd like to ask more about the Chinese version. Should I take it in a general sense, or is there any objective requirement in this connection? And DOJ? I'll first start with the concept behind it. According to the provisions, the organization will be dissolved in accordance with Clause 60. But if the person or persons still act in the name of the organization, there will be relevant offenses. Logically speaking, the organization has already been dissolved. The fact that we add this provision is that under common law there is a concept of holding out. When somebody still claims that one is acting in the name of the organization, that explains the concept behind it. That is exactly why we use the word holds itself out to cover a wider scope, to show that one acts in the name of an organization. I'm not sure if I answer your question. Well, based on what I know, to a certain degree, when an organization is dissolved, I mean, the person gives others the impression that one is doing something on behalf of the organization, and that is also a way of holding itself out. This may not be the case, but it gives others the feeling that a person is, to a certain extent, concerned with the organization that has already been dissolved. Yes, indeed, that is by way of language or act. One gives the impression to others, whether explicitly or implicitly, that one is acting on behalf of the organization or is in relation to the organization. Mr. Holden Chow, the English text is clearer, that is, holds itself out. This is clear as one needs to make announcements to let others know. The phrase holds itself out is more commonly used and frequently used in the laws of Hong Kong. I understand that the Chinese version will prevail at the end of the day. It's all right when we have already explained the word in Chinese 形式, that is in English, holds itself out. Making insinuations to different people does not count. That is when you in private tell other people and you insinuate that you belong to an organization. It does not seem that one is under a shadow organization. One needs to make announcements to explicitly tell others that a person belongs to a shadow organization. I'm not sure if I understand this point correctly, but I just wrote on Mr. Tony Che's question. Dr. Kennedy Wong. Thank you, Chairman. The word 形式 is in English holds itself out. But then in some cases the phrase appears to be is used, as in Chinese 看起來看像. From the perspective of the administration or from the perspective of evidence, will it be easier to collect evidence with the word appearing to be? Because in the case of holding itself out, one can say that one does not have the intention to hold out.
Monsieur, let me clarify once again, and let me first explain the rationale behind this provision. After prohibiting this organization, we have a number of offenses, such as prohibiting a person from participating in an activity of the prohibited organization or holding office to act on behalf of the organization, inviting others to join the organization, or inviting donations. Despite this organization being a prohibited one, you continue to hold yourself out as an office bearer holding certain position in this organization, and then you invite others to join. So if you either claim that you're an office bearer, or you do something indirectly to imply that you are somehow related to this organization, even without telling others exactly the position you hold in this organization, it is still to be prohibited. So to answer members' question about using the term appears to be, then it seems to be too broad in scope. We need this person to engage in an act of telling others that you are related to this organization, such as telling others directly or participating in a meeting of this organization. If the expression appears to be is used, it is too broad in scope. So we need to consider the thing in context. Mr. Chan Siu-hong. Thank you, Chairman. I thank the law officer for further clarifying the position of this expression holds itself out, so on and so forth. In fact, I asked about shadow organizations. If they are prohibited organizations, why are there shadow organizations or organizations prohibited under the clause? Now I understand what the law officer said. That is, being explicit or implicit. After this organization has been prohibited, there may still be activities organized by the prohibited organization. They may operate underground, and this can be caught under this clause. In some circumstances, this prohibited organization may cease operation, and then another organization may be established as a result. And in inviting others to join or inviting donation, this person then makes a claim that this is related to this prohibited organization. So this is again caught by the provision. Let's see if my understanding is correct. This will become a shadow organization of the prohibited organization. Yes, I fully agree with what Mr. Chen said. His understanding is correct. Dr. Loy Kwok. In fact, I wanted to ask a similar question. Well, this person may not claim himself to be a shadow organization of the prohibited organization, either implicitly or explicitly. If the organization then organizes activities, inviting others to join, or inviting donation, or charging membership fees, this is still a shadow organization, and that this provision applies. Law officer, as I said, to be a shadow organization, we need the individuals to make certain claims, either implicitly or explicitly. They may be holding activities of a similar nature of the prohibited organizations. Now, this individual may call this organization another name. So if it is a shadow organization, the secretary may prohibit the operation of the organization according to Clause 58. And if then there is a claim of the name of the organization being a shadow organization related to the prohibited one, then this may be caught under this provision as a shadow organization. If there is no correlation between the two organizations, this organization may still be caught under Clause 58. So if the relevant acts contravene clauses 59, 60, 61, so on and so forth, then albeit not a shadow organization, the provisions still apply. These are offenses after the organization has been prohibited. If the organization has yet to be prohibited, then the offense provisions do not apply. Now, the situation about a shadow organization is that after this organization has been prohibited, the individuals continue to act in the capacity of an office bearer of the prohibited organization, or saying that this organization is related to the prohibited one. Now, let me spell out the question for you. Say if this organization has been prohibited, and if there is an act involving clauses 60 to 62 or 63, despite having 63A, even if you're not acting in the capacity of a shadow organization, if you continue to participate in the prohibited organization, or if you continue to engage in acts relating to clauses 60 to 63, you are still in breach of the law. Is that right? Monsieur Chairman. Well, this is a rather complex legal concept. Apart from the shadow organization as described by the Mr. Chan, if we take a look at clause 59.1, this organization is a local prohibited organization which has dissolved according to the law. Then after dissolution of the local organization, this individual may claim that he is no longer a member of this organization. That is why we now provide the shadow organization provision. As long as you still act in the capacity of this prohibited organization, you'll still be caught. DS, anything to add? No? Ms. Carmen Can. Thank you, Chairman. About the expression holding out, Chairman, of course, you must know this is a legalese. I want to know whether there is consistency between Chinese and English text, and I think the legal advisor can confirm this point. Say in other statutes, is it appropriate to use this similar term, holding itself out, etc.? About organization A and organization B, I heard what the administration say. They've adopted the concept of a shadow organization. Now, I'd say I support this provision. It meets the purpose. Say organization is prohibited, and then another organization is holding itself out to be that organization or another organization. So after reading subclause 3, I'd say that the purpose is met. The first question, would the LDD please take this one? Second, DS, perhaps you take the latter one. I thank Ms. Carmen Can for the question. Holding out is usually translated as 停止 in Chinese. This term can be found in different pieces of legislation. DS. I think we're talking about 3 scenarios. First, this prohibited organization continues to operate in the name of the prohibited organization, and this, of course, will be caught by the clause. There is also the other concept, shadow organization. We don't need to go through the legal procedure of prohibiting this organization, as long as there is evidence to show that the shadow organization is a continuation of the prohibited organization, then the provision still applies. I reckon members were asking this. Some organizations may, in some way, similar to the prohibited organizations, but they may not be such that they could be defined as a shadow organization. That depends on the circumstances of the case. If at the end of the day this organization is found to be a shadow organization of the prohibited organization, then the Secretary of Security can exercise the powers as prescribed. Otherwise, the Secretary for Security will need to go through the steps of prohibiting a local organization before the relevant penalties apply. Mrs. Regina, if I ask this same question at the scrutiny stage, if there is an express provision prohibiting shadow organizations, then the anti-China elements would rather set up a new organization, I think. What if it's an online platform? According to clause 58.3, the definition of and this organization does not include an online platform. Say if we're talking about doing business, selling roasted goose, then perhaps you can have some shadow shops, some fake shops. Now, if you set up an online platform, this cannot be dealt with by local legislation. Will it be dealt with by the HKNSL? I think the element of the offense is whether this is a shadow organization or prohibited organization. This organization may either have a physical address or an online platform, as long as a group of people sharing the same idea, goal, or purpose come together to engage in certain activities, then whether or not there is a physical address, whether a physical premises exists for them together, or as long as they gather on the online platform, this will apply. But if you take a look at 58.3a and then Roman numeral 1 to 3, they are either a company registered under the company's ordinance, or a company registered under the former company's ordinance, or a non-Hong Kong company as defined by the section of the CO, that is non-Hong Kong company. It's an organization. For 3A, Roman numerals 1 to 3 are the exclusion clauses. That means the organization mentioned does not include, as spelled out here in 3A, Roman numeral 1, a company registered under the company's ordinance, 2, a company registered under the former company's ordinance, and 3, a non-Hong Kong company as defined by the CO. We exclude these three types of companies because there is another mechanism under the company's ordinance, and in Cap 32 there is a proper winding up mechanism regulating these companies. If they engage in acts that may prejudice national security, the Chief Executive in Council can invoke certain mechanism to have them deregistered. So here we are excluding these companies from the meaning of prohibited organizations. Would the law officer please tell me which provision expressly cover non-registered companies in the form of an online platform? Let me put it this way. There is no regard as the mode of operation of the organization. if this organization does not have a registered address, if it doesn't operate in a commercial building in Hong Kong and yet it operates in some way, such as a Facebook page or an online platform proclaiming to be a certain organization, and that it engages in activities such as inviting donations and sponsorship, then it is caught by this provision. There is no requirement for this organization to operate in a physical address. Reverend Peter Kuhn. Just now, the administration said using the term appears to be is too broad in scope. I urge the administration to rethink, because Safeguarding National Security Ordinance aims to capture acts of endangering national security. We are talking about some special circumstances. It's not the same as a roast goose shop. This is a specific circumstance. The context is to safeguard national security. It's not just any business in general. Any response from the administration? Now, I think this clause is unique in a sense that when it comes to shadow organizations, once the definition is met, criminal liability can be incurred. When a criminal element is involved, we need to be careful in the use of words. So we find the use of the term 顯示 in Chinese or holds itself out to be a more suitable expression. If there are no other questions, please continue. Next, clause 72. Application of this subdivision to persons arrested for offences endangering national security. Page 39, subclause 2. We are amending the reference to section 73 to section 75, because upon review, the clause that should be referred to is 75(1), which empowers the court to extend the period of detention. Any questions? If not, clause 74, subclause 2, please. This is about court hearings of applications for extension of detention period. During the scrutiny of the bill, some members were of the view that we should make it clear what a reasonable period means. This is provided in subclause 2 of clause 74. That is, A, the magistrate may adjourn the hearing of the application for a reasonable period to enable the person to be represented by a solicitor or counsel. That is, if the person is not represented by a solicitor or counsel but wishes to be so represented. And then we add the following. And the period must not exceed, and then 1, for the first application after the arrested person's arrest, 7 days after the expiry of the first detention period, and 2, for any subsequent application, 7 days after the expiry of the last period of extension, or 14 days after the expiry of the first detention period, whichever is earlier. Then 2b. Upon review, in the Chinese text, we considered the word "hor" not necessary. It will be deleted. So now it reads, the arrested person is to be delivered to the police for detention in their custody during the adjournment. Dr. Kennedy Wong. Thank you, Chairman. During the scrutiny of the bill, I asked whether the word "hor" in Chinese, meaning may, can be changed to soy, which means must in English. Now I see it reads is to be delivered to the police. That's what the English version says. The original reads the arrested person may be delivered to the police. Now it's is to be delivered to the police. There should be, well, there is a verb in English, but in Chinese the verb is missing. So please enlighten me, LDD. What does it mean?
Ms. Wong. I thank Dr. Kennedy Wong for the question. There are grammatical differences between the Chinese and English version. Here, the word gao serves as the verb in Chinese version. It means to be delivered to the police. We decided not to add so here in the Chinese version because it may imply that there is a need to perform a certain duty or obligation. We just want to make it clear here that the arrested person would be delivered to the police for detention in their custody during the adjournment instead of imposing certain duty or responsibility on any parties. So we think it is sufficient to simply delete the word "ho" in Chinese. Any follow-up? Well, new things learned. Thank you. Mr. Holden Chow. During the scrutiny of the bill, I was thinking that arrested persons may want to find a lawyer and the magistrate may adjourn the hearing for a couple weeks for the arrested person to engage a lawyer. Well, in this context, this may not apply because the arrested person would have to be detained in custody. I'm glad that the drafting division makes it clear how long the detention period would be. So I agree to the amendment. All right. If there are no further questions, please move on. Thank you. Clause 76, please refer to page 41 of the English version. It's about consultation with relevant particular legal representatives. Well, the original wording is lawyers. We are now changing it to legal representatives. The amendments to clauses 76 and 77 are recommended taking into account members' views that the reference to lawyer may bring about ambiguity and that it is inconsistent with the terms used in other clauses. Therefore, we propose to revise the term lawyer into legal representative, and we are adding a definition of the term in subclause 7. Bracket 1, bracket 3, and bracket 4, we've changed all the instances where there is mention about lawyer to legal representative. In the following page, we are again changing all the instances where lawyer appears into legal representative. And we're adding a definition for legal representative, which means a solicitor or a counsel. There is another definition provided for here, that is for Hong Kong firm. It has the meaning given by Section 2(1) of the Legal Practitioners Ordinance. Mr. Jeffrey Lam. I mentioned about the wording for clauses 74, 76, and 77. I asked whether the wording could be made consistent. I think the amendment proposed here can help plug the loophole and avoid any unnecessary disputes on what a lawyer means. I cited Cap 159, the Legal Practitioners Ordinance, when I raised the opinion about the definition of lawyer. So I think it is good that the term legal representative is used instead because it will cover all legal representatives. So I support this amendment. Dr. Kennedy Wong. Thank you, Chairman. Now, 法律代表 in English is legal representative in the amendment. And for the definition of legal representative, you say it means a solicitor or counsel. How come you don't use the word barrister? Instead, you use counsel. How would the Bar Association view this? According to Cap 1, the Interpretation and General Clauses Ordinance, legal representative also covers counsel. And we, in accordance with Chapter 1 of Cap 1, when we decided to adopt the word counsel. Also, in other instances of this clause, for instance, clause 74, we also used the word counsel. Any follow-up question? Well, Chairman, you're a counsel yourself. If you find it all right, then I have no problems with it. I thank Dr. Kennedy Wong for mentioning me here. If you have no follow-up questions, it will be my turn. Here, legal representative means a solicitor or counsel. Do you mean any solicitors or counsels, or solicitors or counsels with the qualification to practice? Say I am a solicitor or a counsel, but if I cease to practice, I can still use my title as a solicitor or counsel because I have the professional qualification. In other countries, there are also solicitors and counsels. I want to know here if you refer to specifically to solicitors or counsels that are allowed to practice in Hong Kong. According to Cap 1 of the law, Section 3, legal representative or lawyer means someone who have the qualification to practice. Say, for instance, one day I decide not to practice. And I will still be a counsel recognized by the Court of First Instance because I have the professional qualification. If I cease to practice in Hong Kong, would I be covered under this part of the clause? Understood? We have thought about this. If you refer to Cap 159, there is a register under the Legal Practitioners Ordinance. If your name is on the register, you'll be covered. However, other than having your name included in the register, you still have to have a certificate. And the definition of lawyer is covered in Cap 1 of our law. Same for the Legal Practitioners Ordinance. You have to have your name to be included in the register, and you have to have the practicing certificate in order to lawfully practice in Hong Kong. So there are two conditions that have to be met. Thank you. If there are no further questions, administration, please continue. Now we come to Clause 77. It's about consultation with legal representatives or lawyers who may be restricted in view of circumstances endangering national security. Again, we're changing lawyers into legal representatives here. So we are changing the title of the clause for the part that involves lawyers, and we're also changing other instances where lawyer is involved into legal representative. We're also adding the definition of legal representative here. Please carry on. Please refer to page 47 of the English version. We've now come to Division 2. The original title for Division 2 is Absconders Charged with Offences Endangering National Security. We propose to delete the word charged with here. Here for clause 86, it's about power of Secretary for Security to specify an absconder for application of certain measures against the absconder. Clause 86, subclause 2a. Upon review, we think that a person may abscond at any stage of criminal proceedings, but not limited to the stage at the magistrate's court. So we propose to amend the scope of clause 86 to make it clear that it applies to the subject of warrant of arrest issued by a court in relation to an offense endangering national security. So we are amending subclause 2a here. For subclause 2c, originally there is a provision, a period of 6 months after the issue of the warrant has expired. Well, most members of this committee strongly oppose to the condition imposed under clause 86(2)(c), which requires that measures against an absconder can only be taken after the warrant of arrest has been issued for 6 months. Members are of the view that the Secretary for Security should be given maximum flexibility to deal with the absconders. So after consideration, we agree with members' views and propose to delete clause 86(2)(c). For subclause 3b, in the light of the reasons given above, we are revising the provision to the person has been brought before a judge or magistrate, as the case may be, instead of before a magistrate. Mr. Holden Chow. Thank you, Chairman. I thank the administration for taking on board the views expressed by members. I am glad that you are removing the part about 6 months. I think you have listened to our views, and I think in order to combat the acts done by absconders, we should remove this part. Mr. Tony Che. I support the amendment proposed by the administration here. As discussed, we were of the view that the period of 6 months is unnecessary. If the Secretary for Security reasonably believes that the person is not in the SAR, it should be sufficient for the Secretary to specify an absconder. There have been absconders who commit acts outside of Hong Kong to endanger national security. Now I'd like the administration to clarify on this. Say the Secretary reasonably believes that the person is not in the Hong Kong SAR, but you don't know where the person is. You don't know if the person has gone on hiding or not. Say, for instance, you don't know where the person is. You don't know whether the person is in Hong Kong or in other places. If the person has absconded for 6 months, what would the administration do? Deputy Secretary. Well, the scenario is covered under the clause mentioned by Mr. Tony Che. Mr. Chen Xiu-hong, for clause 86(3)(b, the administration added the words "as the case may be" in brackets. I want to know why this is added here, and who should decide how or whether it is the case as may be. Mr. Leung. We add the word judge and the words "as the case may be." Well, we add the word as the case may be, because we add the word judge here. For clause 86 bracket 2a, we are proposing an amendment here. Originally, it's that a magistrate would issue a warrant. However, defendants who commit acts endangering national security, for those who are on bail after being charged, they may abscond. And it may not be the case that a magistrate issues a warrant. It may be a judge of the district court or the court of first instance who issued a warrant. So as long as an arrest warrant has been issued to the person, then it would satisfy the condition here. So it depends on who issues the arrest warrant, then the person would be taken to that judge or magistrate who issues the warrant. I understand now. Thank you. Administration, please carry on. Thank you, Chairman. We now come to Clause 88, prohibition against certain activities in connection with immovable property. We add the part subclause 6 here. There are views from members that if an innocent third party has leased a property from an absconder before the absconder is specified by the Secretary for Security, the third party will instantly commit an offense. While the Secretary for Security may address this by granting a license, we propose that such a situation be clearly excluded. Also, according to Clause 87 of the bill, the rent paid by the tenant will be frozen after being deposited into the account of the absconder. So the proposed arrangement will not benefit the absconder in practice. Therefore, we are adding subclause 6 here. If a person does an act mentioned in subsection 2 under a contract, agreement, or obligation that arose before the date on which the relevant absconder became a relevant absconder, the person is not to be regarded as having contravened that subsection by reason only of that act. Mr. Tommy Chen. I understand the original intent of Clause 88. I was worried that those who had entered into contract or who had served as a shareholder might be affected. And I think the amendment here would make it clear, and I welcome this amendment. Mr. Kitson Yang. Thank you, Chairman. I also welcome this amendment to add subclause 6 here. We were concerned that an innocent third party who has leased a property from an absconder would instantly commit an offense. With this addition, it would be clear to the general public that innocent party won't commit an offense even if they have leased a property from an absconder. Reverend Peter Kuhn. With this addition of provision, if a person wants to continue to reside in the property that he or she has leased from an absconder, would a permission be required from the Secretary? Deputy Secretary. No such permission would be required because the contract or agreement that the person has entered into would not fall within this category. Chairman, I think this amendment helps clarify things and alleviate concerns of the business sector. There are many normal collaborations or financing projects in Hong Kong. How would you know if a person has suddenly become a spy? You would never know. So the amendment here would alleviate the concerns of the business sector. For investors or new investors, this is a very important message. As we continue to attract businesses and enterprises to Hong Kong, we can send a message to potential investors that they should not be worried. Thank you.
Myself, I'm not going to repeat the point the members have already expressed. I believe that is pretty much what I wanted to say. Next, Dr. Loy Kwok. Thank you, Chairman. If there are people who are suspected of endangering national security before they are convicted and they abscond, they are dragging others in hot waters. For instance, when there is going to be business interactions, operation, and so on, people will be affected. So in the Bills Committee, we also raised similar concerns. I have to thank the government for being receptive to our ideas, and I support this amendment. Next, Mr. Chen Siu-hong. Thank you, Chairman. Adding subclause 6, in response to our discussion on last occasion on handling those who are innocent when they have entered into contracts, if one has to seek permission from the Secretary of Security, that would be quite troublesome. People are dragged in hot waters innocently. If some contracts have already been entered into, they shouldn't be considered to be in breach of this subsection or subclause. Before people abscond, if they deliberately sign contracts or enter into agreement with others and they exploit this loophole to continue to get money, this loophole could be plugged. Like I can see from the footnote, when they entered into agreements on purpose, this would not be exploited as a loophole. So, taking into account the context, I support this amendment. Dr. Kennedy Wong. In Chinese, there's the word gan. In English, it is by reason only of that act. This drafting is quite good. I'd like to ask the administration, when you say in the footnote that with the newly added subclause 6, one will not be seen to be in breach of this subclause by reason only of that act. When the asset is in the account of a person, it will not be frozen, but the tenant will not be in breach of the law either. Will it be the case that the tenant becomes someone who can reap the gain? For the absconder and the tenant, the contractual relationship is one matter. We don't want the monetary interactions between the absconder and the tenant to assist the absconder to abscond. So we need to look at this matter separately. If there are no further questions, please continue. Thank you, Chairman. Clause 92, Clause 89 in page 50 of the English text. Prohibition in connection with joint ventures or partnerships with relevant absconders. Like Clause 88, we will also add subclause 6. If a person does an act mentioned in subsection 2 under a contract, agreement, or obligation that arose before the date on which the relevant absconder became a relevant absconder, the person is not to be regarded as having contravened that subsection by reason only of that act. During the scrutiny of the bill, members are of the view that to stipulate that a person is not to be regarded as having contravened Clause 89 brackets 2 by reason only of entering into any contract, agreement, or obligation with a person before the date on which the person becomes a relevant absconder. Mr. Holden Chow. Thank you, Chairman. I also welcome this amendment. It's a situational question. After we add subclause 6, if person A and person B set up a company, and if person B breaches the national security law and has already gone into hiding, the partnership will not be in breach of the law. But what about joint venture? This company founded by persons A and B after the addition of subclause 6, does the company not need to apply for a permission or a license from the administration for joint venture? For example, if person B has already absconded, one needs to apply for a license before one knows how the future will hold. But now with subclause 6, that is spared. Does it mean the person A, as the only director, does not have to seek a license, does not have to apply for a license, I mean? Yes, your question is clear. For the contract per se, the contract will not fall into the scope into this regulation under this subclause. But that concerns the monetary transactions. So the target is the monetary transactions. That is the perspective. Well, I think the crux of the matter is the phrase by reason only of that act. Yes, this is the key, by reason only of that act. It's not a sweeping statement, so to speak. It's only by reason only of that act. So the point is to while you are handling the money of the company, you need to apply for a license. Yes, I understand that. Thank you. Mr. Tommy Zhang. Thank you, Chairman. I need to thank the administration for adding subsection or subclause 6 under clauses 88 and 89. These ease the concerns of businessmen. I'm a little bit worried when there are not many of these cases when businessmen have read this ordinance or this provision. They won't just go to the Secretary for Security to apply for a license in terms of the allocation of assets or the handling of assets. They don't know that even for interest, they also need to apply for licenses. For interests, in clause 86, clause 87 in subclause 6 regarding absconders. directly or indirectly owned or controlled by a relevant absconder, interest or other earnings due on that account, and B, payment due under contracts, agreements, or obligations that arose before the date on which the relevant absconder becomes a relevant absconder. But in subsection 6, we add by reason only of that act. These are not affected. But if afterwards you need to discuss with that person, making more injections, entering into partnership, you'll have to apply for a license from the Secretary for Security. Be it dividends or wages, this will also fall within the scope of Clause 87, bracket 6. It is exempted. Dr. Lo Wai Kwok. Thank you, Chairman. Just now, while I was speaking in the first round, I pointed out that this amendment has laid the concerns of people, that is for collaboration before abscondment. But people will still drag others in hot waters. They will continue to do so. In the conduct of businesses, there are restrictions. There will also be follow-up in relation to the temporary removal from office of director. When people have joint venture or partnership, they will still have to deal with that. They still need to deal with that. It is not the case that they don't need to do anything at all. Well, the crux of the matter is still the phrase by reason only of that act. Dr. Kennedy Wong. Just now I mentioned Clause 88, bracket 6, which is newly added. I'd like to once again say that if some persons there's actually space. Well, in accordance with Clause 89, when somebody has left Hong Kong, the remaining directors they will just act in accordance with their own interest. In Clause 89, subsection 6, that is a safeguard. Well, I think the enforcement agency needs to face this and needs to grapple with this situation. Well, when you are the partner of that person, you don't know how to deal with the business. There are company laws regulating the relevant behavior. I understand some people are worried, but there is a well-established and well-written company law in Hong Kong. In subsequent provisions, when we mention shareholders, if there are simply two shareholders, the situation will be more difficult to handle. When one knows the situation but one does not act in accordance with it, that should be less frequent. But I understand the frustration of the government. Clause 92, proposed amendment. Clause 92, temporary removal from office of director. Well, in Clause 29, Subsection 4, any power that a person may exercise under the Constitution, rules, or other governing documents by which the company is constituted or according to which the company operates in relation to a relevant absconder. That is why in Subclause 4, under Clause 92, we further amend the amendment. We separate it into two. A. Any power that a person may exercise under the law of the Hong Kong SAR in relation to a relevant absconder, or B. Any power that a person may exercise under the Constitution, rules, or other governing documents by which the company is constituted or according to which the company operates in relation to a relevant absconder. Mr. Jeffrey Lam. On the role of director, in some cases, a company only has two directors. In the absence of one director, the other one cannot make the decisions. Now there are companies that only have two directors, and this clarifies the situation for these cases. I thank the government for setting out this scenario clearly, and that should provide clarity for the business sector. Mr. Tommy Zhang. There are hundreds of thousands of companies of this scale. This provision actually helps the business sector. I thank the administration for making this amendment. Let's take a break right here. Agenda item number 2, any other business? No. I'd like to remind members that the Bills Committee will continue with the next meeting at 11:10. Meeting adjourned.